Katanga, Mole, Kakwenze, after the fact of murder on a charge sheet with a count of murder was incorrect, illegal, improper, and irregular. Two, that the land chief magistrate had no jurisdiction to take a plea of the respondents on a charge sheet where there is a count of a capital offense of murder, which is only triable by the High Court. And three, that the finding and the ruling of plea of not guilty by the chief magistrate in respect of the respondents be set aside. The application was supported by an affidavit shown by Anna Chiza, Chief State Attorney. And the section 17(1) and 33 of the Judicature Act and the Rule 2 of the Judicature Criminal Procedure Application. We are jointly charged with, on the same charge sheet with A1, one Katanga Mole, who is charged with murder contrary to section 188 and 89 and 189 of the Penal Code Act. A2 Kakwanza, Patricia, A3 Nkwanzi, Martha Katanga are charged with destroying evidence contrary to section 102 of the Penal Code Act, while A4 Otai Charles and A5 Amanyere Charles are charged with being accessory after the fact of murder under section 392(1) of the Penal Code Act. The powers of this court in criminal revision are laid out in sections 48 and 50 of the Criminal Procedure Code Act. In this particular case, the main issue for consideration of this court is to determine whether the magistrate had jurisdiction to take plea on a charge sheet with a count of murder. It is argued by the applicant that the magistrate didn't have jurisdiction to take pleas of A2, A3, F1, and A5. The basis for this argument is that they are jointly charged with A1, who is charged with a capital offense for which the chief magistrate lacks jurisdiction. Jurisdiction means and includes any authority conferred by the law upon the court to decide or adjudicate any dispute between the parties or pass judgment or any order. A court cannot entertain a cause which it has no jurisdiction to adjudicate upon. Issues of jurisdiction are substantive to the extent that they go to the core of a case, and if a court lacks a jurisdiction, whether pecuniary or territorial, over the subject matter, its judgment and orders, however precisely cited and technically correct, are of no legal consequence, and they may not only be set aside anytime by the court in which they are rendered, but declared void in every court in which they are presented. See the case of Gavula Benefancio versus Wachidalu Meraso, that is the Ginger High Court authority. It is not in dispute that the chief magistrate is closed with the jurisdiction to hear and examine the offense of destroying evidence under section 102 of the Penal Code Act, and that of being accessory after the fact of murder contrary to section 392 subsection 1 of the Penal Code Act. The charge sheet in the instant case, however, contains a count of murder which is clearly outside the jurisdiction of the Chief Magistrate's Court. The question to determine is whether in those circumstances the Chief Magistrate was closed with the jurisdiction to handle the matter. In the case of Uganda versus Ndiamuhaki Julius and others, that was criminal revision, was the number 1 of 2016 of Kabale Court. The court held the practice in such cases is that the gravest offense in a multiple count charge sheet determines the jurisdiction. The count of murder in this case determined the jurisdiction of which court could handle this case. Now, that is the ruling of the court in that case, that the count of murder in that case determined the jurisdiction of which court could handle the case. I find no reason to depart from that decision. The magistrate was therefore only required to read the charges and advise the respondents that he did not have jurisdiction to hear the case, and that they would take a plea or apply for bail in a court with a competent jurisdiction, and thereafter remand them. The purported actions taken by the land chief magistrate were irregular and a nullity at law. He had no power to take a plea on a charge sheet that contained a count of murder. It's only a court with jurisdiction over all the courts, over all the counts in the charge sheet that has the jurisdiction to take plea here and determine the case or grant bail. The above notwithstanding, the DPP also has power to determine the offences to be committed to the High Court for trial if the Magistrates Court has, even if the Magistrates Court has jurisdiction over the same. This is provided for under Section 169 of the Magistrates Court Act. In the result, I find that the land chief magistrate had no jurisdiction to take plea given the nature of the charges presented before him. The resultant pleas are hereby set aside for being irregular and a nullity. The respondent shall take plea at the commencement of the trial before a court of competent jurisdiction. I so order. Yes, please.
Clients who are just given birth needs a chair to sit. Is it okay if we give her a chair? She can sit? Much obliged, my lord. My lord, at the last hearing, we had also said we would mention the... Oh, no, I'm sorry. Someone, you want to introduce or we introduce?
Want to introduce us and
Yeah.
My lord, may it please you for the summary. I am I am introducing them, and the applicants are representing. This one is information.
You understand? What about the advisory watching brief? My lord, this matter is coming up for mention. My lord, we filed and served the application and affidavits in support of the application. The application and the affidavits in support of the application on the 10th of January 2024. My lord, the respondent filed an affidavit in opposition on the 17th of January. And therefore, my lord, plead on the 17th of January, my lord. My Lord, we are ready to proceed. Much obliged, my Lord.
My Lord, we should clarify that the affidavit that we filed on the 17th was for the hearing then. As of today, we are not ready to. Yes, my Lord. We are there possible by appointment to be able to attend to the hearing of the day application. Appear to hear the bail application, to respond to the bail application. Yes, my Lord.
Yes, my Lord, and that's what I was going to say, just to inform that fixing.
Tomorrow we can hear. Tomorrow.
Yes, my Lord, it's about the fixing that I'm talking about. Because, my Lord, the last time we were before you.
Come from here.
You see, what fixes this here is, I don't know what kind of it.
No, my Lord, I just
make a comment and we move on.
Yes, it's a simple comment, my Lord. My colleague, the last time we were before you had indicated that they would be available today and tomorrow. So I had hoped that she would say we are not ready today, but since we had also proposed tomorrow, exactly, I had hoped that because last time they had indicated they would be available on the 24th and 25th. So my Lord, I proposed that then she says whether she's still available on the 25th tomorrow, so that we can come and hear the same. Much obliged.
I have never.
What time, my Lord?
Much obliged.
Much obliged, my Lord.
After that, we are going to
Yes. Much obliged, my Lord.
Okay, let's do the check.
It is there. For the gentleman. We're discussing with our clients.
People are there. 4.
There are 4, my lord.
Okay. There are 4 applicants, isn't
There are
it?
4 applicants, yes, in their road.
Uh-huh.
So, my lord, for the record, all the 4 applicants are in court. And my lord, my name is Jet Tumwebazi. We are joined together with my valued brother, Mr. Edison Katanga. Introduce themselves and see it's a high-powered delegation. So, yeah.
Some of my brother and assistant about the prosecution. I am appearing more than my lord.